I call Stuart Nash.
Thank you very much, Mr. Chair. We're debating part 2 of the Legal Services Bill here, and I'd like to talk really about clause 6, 7. I'm going to talk about clause 8, and then I'm going to go on to schedule 1, if I may, Mr. Chair, because I think some of these things need clarifying for a lot of people. But one thing I would say before I'd like to start, is Simon Bridges did comment that about 40% of the bills through this House were from the Justice Select Committee. I think you noted, Mr. Bridges, and I find it quite surprising that, in fact, the Justice Minister has decided to resign. I wonder if the reason for that is because he feels that he's the only one doing any work in the Cabinet.
Retired.
And he's just sick of this, and he realises that there are better options out here. He's sick of carrying the national government because he seems to be the only one with a plan. No one else has any plan on that side of the House. But back to the bill, Mr. Chair. Part 2 actually deals with when legal aid may be granted. And as a non-lawyer, I'm sort of aware there are 2 types of cases. You've got the criminal matters and you get civil matters. Clause 6 actually deals with criminal matters. And I think a lot of the arguments you read in the press, or if you go down to the pub or the Cosy Club, you'll hear a lot of New Zealanders say, goodness me, that guy's just been done and he's appealing under legal aid. That just isn't right. But if you look at part 1, and the rule of justice, it actually is it's a fundamental tenet of our legal system that everyone has the right to a fair trial. So the point that I would like to make, Mr. Chair, is clause 6 sets out the proceedings for which legal aid may be granted in criminal matters. And it actually lists criminal proceedings in a district court, a youth court, a high court, court of appeal, or the Supreme Court. So in fact what you've got here, Mr. Chair, is in fact anyone, not you, Mr. Chair, you'll never need legal aid, I know that, any New Zealander who is in need of any New Zealander who is facing a criminal matter in any court has the right to legal representation. I think that underpins our whole democracy, no matter how at times unfair that may be. If we go down to clause 7, Mr. Chair, it talks about proceedings in which legal aid may be granted in civil matters. And people, in fact, may be surprised to learn that subclause E points out, for example, if the Commissioner considers that a case is one that requires legal representation, this may be in the Maori Land Court, the Maori Appellant Court, the Employment Court, the Employment Relations Authority, or any other administrative tribunal or judicial authority. As set out, possibly the Privileges Committee. In fact, Mr. Parker brings up a good point. I think legal aid has been pulled in and has been used in this. But back to what Mr. Robinson was saying, when can this be granted? Okay, it can be granted in legal matters when the applicant is a natural person. So this assumes that a body corporate or a company can't apply for legal aid. You've got to be a natural person. This is what, by the way, I'm talking about clause 8 here, Mr. Chair. Part 2, when considering whether the interests of justice require that their applicant be granted legal aid, the Commissioner must have regard to, and I go down to part 3 here, when determining an applicant has sufficient means to enable him or her to obtain legal assistance. This goes in regard to the applicant's income and disposable capital as set out in Schedule 1. Now if we go to Schedule 1, Mr. Chair, it sets out the definition of what capital actually relates to. This is in relation to an applicant for legal aid means persons' total assets after deducting the amount of any debt secured against those assets and the amount of actual debts of the person other than those secured. Now, and it has a definition of income. Now, this is quite an important argument because I don't know if people remember, but there was a case very recently when a rather wealthy gentleman who had been a director of a finance company applied for legal aid. Now there was a huge hue and cry about this because people thought that this man was a very wealthy man, he had substantial assets, but he was applying for legal aid. When the perception of people applying for legal aid are those who actually have nothing, who can't afford a lawyer. And if you look at this definition here, his lawyer, his legal counsel, must have looked at the definitions and applied the test and assumed that this incredibly wealthy man who still lived on Remuera at the time, lived in a big house on Remuera Road, drove a Porsche, didn't have sufficient capital, didn't have a home, Mr.
Call the Honourable David Parker.
Thank you, Mr. Chairman. I want to also address